Okay. We're going live in this case on cause number DC 207333, Mark Hume versus Edward Delgado. Counsel, make your appearances.
Good morning, Your Honor. Julie Pettit on behalf of the plaintiffs.
Good morning, Your Honor. Chris Cradaville and Israel Silvis on behalf of the defendant, Mr. Delgado.
Is that everyone?
I believe so.
Your Honor, Mr. Riley is here in the room with me, and Ms. McIntyre is also here via video.
Great. Okay, so we're here on a motion for continuance. I've read all the briefing on this, and I do want to, before we hear argument, I do want to hear argument from both sides. I thought the briefing was really good, really well done on both sides. I just want to kind of, depending on how I rule, I do want to kind of set certain parameters of things that I'm considering and why I'm considering. I believe that, is Greg Money on this case? You know Greg Money, I'll just let him in, I guess. So first off, the issue before us is whether or not to grant a continuance of this hearing day, or sorry, trial date next month or next week. And part of the issue here is whether or not there would be prejudice to the defendant if the court failed to grant that. And so a few things that I want to make clear on the record that I am considering. One is that we have not had jury trials, regular jury trials for over 15 months due to COVID. Dallas County did allow a rotational system starting in the beginning of June, where each judge was essentially given 1 day a month to try jury trials. That rotational system ends on July 19th. And so starting on July 19th, Dallas County judges in the George Allen Courthouse will be able to go back to normal jury trials. In addition, the Office of Court Administration has indicated that they believe that the backlog for judges in Dallas County, according to what I've heard, is about 3 years, and that's probably about right in this court as well, given the incredible backlog we have due to the inability to try jury trials. Another factor in all of this is that the Dallas County has also, through our local administrative district judge, eliminated essentially all of the non-jury weeks between now and the end of the year. I think we have 1 week for the week of Thanksgiving, and I think that's basically it. And so if we don't try this as a non-jury case in the next 2 weeks, we could potentially try this on December 28th. I do have over, I believe my last count, and Rhonda can correct me, is I believe we have over 40 cases set for trial on December 28th on our one non-jury docket of the year. And so, and also this case is relatively new. So the way the 68th calls their dockets generally is we try jury cases first and then non-jury cases. The jury cases, we go from the oldest to the newest, and then we try the non-jury cases from oldest to newest, is how we typically do that during jury weeks. And so my estimate is that this case doesn't go to trial in the next 2 weeks as a non-jury case, there will be a significant delay in getting this case to trial given the COVID backlog. So I just wanted to make that clear on the record as part of something that I'm considering in my analysis of whether or not there would be prejudice to the defendant in this case if we don't go to trial in the next 2 weeks. That being said, I have looked at the briefing on both sides. I know there's a number of cases that have discussed judges who refuse to allow parties to pay a jury fee late and been reversed on that account. And so I do want to, I do want to talk about those cases and see how they fit within the parameters of what we have currently in the 68th District Court in our docket. So anyway, I'll let, who would like to start today?
I'll be happy to start, Your Honor.
Okay.
We had filed, I think there was some question last, I guess it was earlier this week actually, on what the procedure should be based on the decision that the court's making, whether it's a motion to strike. We believed after the hearing and looking at it that we thought the correct procedural mechanism, and when I say we, I'm talking on behalf of the plaintiffs, was still their motion to continuance, but then a motion for non-jury trial. We, after looking at it further, didn't think it needed to be a motion to strike because the case has been set on the non-jury docket since the very first time the court sent a trial notice. And that has been the case unchallenged by either the plaintiffs or the defendants. So for that reason, we did file a motion for non-jury trial, which is set on the court's docket today, along with the defendant's motion for continuance. What I would like to address just briefly, Your Honor, is a couple of different issues. First, I think the Gale case, which both parties have cited to from the Texas Supreme Court in 1997, is very instructive. And it gives a very narrow instance in which the court could rule for the defendant's position in this case, but it indicates that an untimely payment of the jury fee is only acceptable in very rare circumstances. And that's if the jury trial can be had without any additional delay. That's the very first element that they would have to meet. And as the court just mentioned, if this were to be switched to a jury trial, our understanding from the court is that could easily be a 3-year backlog. So for that reason, they don't even get past step 1 in this narrow exception because it would absolutely cause additional delay if this were switched to the jury docket. The second elements are interference with the trial court's docket and injury to the opposing party. And we think that a 3-year backlog of cases that we would be sifting through certainly would not allow them to meet bullet point 2 or bullet point 3. So we think the inquiry ends there pursuant to that Gale case. Now, the defendants have certainly cited a number of cases in their briefing, and I'm certainly prepared to go through each and every one, but I won't do that because there are quite a few cases. But what I do want to say, Your Honor, is that in short, the defendants have not cited, Your Honor, to a single case in which a jury trial would have caused the delay. And the cases that they have cited are very clear that if there is a delay, it is proper for the court to deny this switch. There is no doubt, and I don't think they can argue otherwise, or they'd be arguing with the court's statement at the beginning of this hearing, which is this is undoubtedly going to cause a delay. From a procedural, I guess from a practical standpoint, we as the plaintiffs had indicated that if they simply think they need more time, we were agreeable to have this heard if the court would special set it on December 28th, but they don't want that. They won't agree to that. So this isn't just a matter of they need these additional items that they are now contending they're seeking. That's simply not, that's not the issue here because we've agreed to do that.
Ms. Pettit, let me ask you a question. This is kind of my big concern here. Are there any cases where a trial judge has been affirmed and the Court of Appeals in any county or any Court of Appeals in Texas affirmed a judge who said, okay, I'm going to strike the jury fee because it's too late? It seems like they cited to quite a few cases where the judge was overturned, but are there any cases where a judge was affirmed? That's kind of my big concern is I think we have probably about as compelling a reason as we could to establish that there would be prejudice and a delay, but I'd like to see a case where the Court of Appeals said, hey, this is a situation where the trial judge is right.
I don't know that I can say definitively. I want to address a couple of the cases that they saw. So I don't have an exact answer to your question, Your Honor. I apologize. I may have one, but I'm just trying to think through whether they were affirmed. I know that we believe each case that they've cited actually went our direction, but whether that was an affirmance or not, I don't want to speak out of turn and say yes or no. But I can, well, perhaps while they're arguing, I might be able to figure out the answer to that. What I do think is critical to note in this particular case is there is not a single motion to compel on file. So that's the problem with the majority of the cases that they are citing to, is that there were some sort of pending motions or issues that needed to be resolved, or the court had, I think it's in the Gale case, where the court had even acknowledged that both sides had agreed that additional discovery was needed. That's not the case here. There should have been diligence on behalf of the defendants if they really needed items or if things were critical. Those motions should have been filed timely, and discovery should have been addressed at that time, not now. Also, I know the defendants are relying on the plaintiff's initial agreement to their request for continuance. But again, that motion that we were unopposed to is very clear that we were asking for an October date, which we've now been aware isn't going to be October 2021. It's going to be 3 years from now. And so we simply can't agree to that, even though we had tentatively agreed to allow them to have a short continuance. The best case I think that the defendants have, they had to go all the way back to 1888. It's the Allen versus Plummer case from 1888. But that extremely old case is involving a completely different rule and a different statutory scheme. We didn't even have the rule that exists now, so I simply don't think that particular case applies. That case goes on and talking about, I don't even understand exactly what they were doing, but they say, in fact, the court expressly recognized that delaying the case until next term would have been prejudicial. So they've got this weird term type system, I guess, that they were using in the 1800s. So we don't think that case has any applicability here. The 1908.
We actually still do have terms, believe it or not. Every term I have to sign an order with to file with the district clerks, but I don't think it's really used the same way it was back then, because it's not like we only have one trial docket each term, but we do still have technically terms. So, but I don't know that it really matters. Just interesting.
Sure, that is certainly interesting. I was not aware of that, but it was a completely different statutory scheme that was being used in the 1800s. On the Aronoff case, which is the 1957 Dallas Court of Appeals case, in that case, both sides had announced ready for trial, and they all thought it was a jury case. So that doesn't even apply at all, because everyone had announced ready, and both sides thought it was a jury trial. The Houston case they cite, which is Dawson versus Jarvis, and in that particular case, there was a jury that was sitting there available at that moment if there was going to be a switch from a bench trial to a jury trial. Obviously, we don't have that luxury on Tuesday. There's no jury sitting there. The Gale case I've already addressed, which is the Texas Supreme Court 1997 case, which I believe is the most relevant. And the EE versus Texas Department of Family Protective Services case, which is the Austin 2020 case. In that one, the mother's jury demand was untimely, but it was filed several months before the final trial on the merits. So it was done. The trial had already been moved several months in advance. On the I think it's DeGelder versus Compton, the Dallas Court of Appeals case. The court said, thus we find that DeGelder established that a jury trial could be conducted without interfering with the court's docket or delaying the trial. Again, we don't have that here. The White Motor versus Ludin case, which is the 1963 Dallas Court of Appeals case. The other party, this is important, had already paid the jury fee. So that case simply doesn't apply. In the N. Ray Rodriguez case, which is the Dallas case from 2020, both parties sought a continuance because by agreement, they had been unable to complete discovery. Again, that doesn't happen here. They rely heavily on a case, Your Honor, called N. Ray Psyche. I think that's how you say it, S-A-K-Y-I, which is a very recent Dallas Court of Appeals case. But in that one, the defendant was seeking third-party discovery that they had already exercised due diligence and getting. So they were trying to get this third-party discovery. It's like two marriages that maybe overlapped or something like that. And so they were already trying to get all of this discovery. And here that simply hasn't happened. They would have needed to show due diligence to obtain the discovery that they're seeking, which hasn't happened. So for those reasons, we think that all of those cases they've cited simply have no relevance. I know they will likely try to rely on the 5-Star Global case, which is a completely separate case that they they refused to, or they didn't want to consolidate with this case. So it's a separate case, and I don't believe that they can rely on issues that they say that they're addressing in a separate case when those should have been dealt with here, and they should have exercised due diligence here if those items are critical. As Your Honor addressed at the last hearing, even if the parties file a joint motion for continuance, the court doesn't have to grant that. The court has discretion to do what the court wants with his own docket. The other thing I would add is there's this ongoing issue with a QuickBooks file. I anticipate they'll address that in their argument. That's something we have provided that to them. I went back and looked this morning. They've had the file since March. I understand that they will say they don't like the way it was produced or whatever, but that file has been in their possession with March. You can open it. You've got to use 2018 QuickBooks. We've told them that over and over, but they have everything that they have sought. They have not been diligent, and they simply do not meet the test that the Texas Supreme Court has laid out. And so we ask that this proceed to trial on Tuesday. One more practical matter is, just so Your Honor is aware, we are mediating this case this afternoon with Judge Metcalf.
Judge, I believe you might be on mute, Your Honor.
Yeah, sorry, go ahead.
Yes, Your Honor. Chris Cradaville on behalf of the defendant, Mr. Delgado. I want to review sort of how we got here, because I think there are two issues that have become intertwined, and they don't need to be intertwined, or they're inadvertently intertwined. The first is what I would refer to as a straightforward meat and potatoes motion to continue that's before this court. And that straightforward motion to continue is based on this being a relatively young case. It's just over a year old. It was filed during the height of the COVID pandemic, with all of the slowdowns, not only in the courts, but also in the discovery process and the slowdown among lawyers that was inherent in the COVID pandemic a year ago, and to some degree continues today. And the fact that just not a lot of discovery has happened. We've had 1.5 depositions. And I think more fundamentally, the parties are due to announce ready or not ready for trial on the next business day, which is Tuesday the 6th, here in about 45 minutes. Yet as of right now, there have been no exhibit lists exchanged, no witness lists exchanged. And as Your Honor knows, under Rule 194.4, that's all due to happen 30 days before trial. None of the normal pretrial exchanges, designations, motions in limine, none of that has happened as of yet, either way, not from the defense, not from the plaintiffs. And so that's why we had what was, as I said, a meat and potatoes motion to continue unopposed up before this court that the court took up on Monday. Now, during the hearing, as Your Honor will recall, we discussed how the grant of that continuance would, as a secondary matter, carry with it a cure of this jury fee issue. That's not the intent of the motion to continue. It's just an old-fashioned motion to continue based on the parties not having complied with Rule 194.4 and made the necessary exchanges. Discovery is not complete. Not a great deal.
I will say this: in 99% of the cases I have, the parties don't comply with that 30-day rule in terms of filing exhibit lists, a witness list 30 days in advance, and so the vast majority of cases, if I'm lucky, if I get those on the day of trial. So I'm not as concerned about that. Obviously, before trial, if we have a jury trial, we want motions and limine filed on the day of trial, exhibit lists and witness lists, but I don't typically enforce those, and I don't think most judges in Dallas County do. But I am concerned if discovery is not done, but it seems like there is some conflict about whether that's the case. Let me ask a question. How long would this case take to try if it was a jury case? How long would it take to try if it's a non-jury case?
Your Honor, I'm going to let my partner, Mr. Silvis, who is lead trial counsel, I'm just here as the nerdy appellate lawyer. Mr. Silvis will take on that trial question.
Good morning, Your Honor. It's Joel Silvis. I actually communicated with Ms. Pettit about that specific question. We both think that it would take, we would request 4 days to try the case, though we would both endeavor to get it done within 3.
For a non-jury or jury?
For a non-jury trial, Your Honor.
Okay.
Your Honor, when we announced ready yesterday, we estimated 3 days. I really think we can get it done in 3. The issues are pretty narrow.
But,
Okay.
Your Honor, if I might resume, just trying to untangle these two related but fundamentally separate issues, the motion to continue and then the issue about the jury fee. And I think what's being overlooked with regard to the jury trial and their motion for non-jury trial, as they've styled it, and whether the court wants to treat that as a motion to strike jury demand, I think it gets us to the same place procedurally. The continuance would, as a side effect, cure the jury fee payment issue. But when we drill down on that issue, there's fundamentally no prejudice to the plaintiffs. Why? Because in their pleadings for the last 13 months, in their original petition, their first amended petition, and indeed, even in their live pleading today, filed on June 25th, the second amended petition, there is a request for jury trial. In the original and the first amended, it's a formal jury demand. In their current live pleading, there's no longer a section style jury demand, but in the prayer, it still asks this court for a jury trial. They are judicially estopped from claiming they would be prejudiced by a jury trial when that is relief that they have affirmatively and consistently requested from the court. It's not prejudice if the court gives you what you ask for. And in this case, both sides have from day one, in the live pleadings to this day and in the live pleadings at the start of the case, always asked for a jury trial. Now, neither side timely paid the jury fee. That's uncontested. That's a matter of record. My side, the defendant, Mr. Delgado, paid the jury fee on a tardy basis as soon as we became aware of the tardiness in an attempt to cure that issue.
I guess my question is, I mean, every single time the notice was sent out by the court, it said it was a non-jury case. So I'm a little confused about why your side, I understand that you guys felt it was some COVID thing, that somehow we were taking away jury trial, your right to a jury trial. And I didn't quite understand that argument.
I think, and I'll let Mr. Silva speak to this as well, since he's the man in the trenches as trial counsel. But I think we'd style that as excusable neglect. We were aware the jury trials were not occurring in Dallas County, and indeed are not normally occurring in Dallas County even now. So when we saw the non-jury calendar entry, we assumed that that was just a recognition that no jury trials were happening. But before I turn it over to Mr. Silva to speak to that, I would say that there, and this is not cited in our papers, I had a feeling this might come up at today's argument. There is a Fort Worth Court of Appeals case, Guyot v. Guyot, which is 3 Southwest 3rd, 243, Fort Worth Appeals, no petition from 1999, which talks about how docket entries are not part of the record and are inherently unreliable. And I will read to you the Guyot court's key language on this, and that's as follows, quote, "In general, a docket entry forms no part of the record which may be considered. It is a memorandum made for the clerk's and the trial court's convenience. One reason for not considering docket entries on appeal is that they are inherently unreliable. An exception to this rule is that a docket entry may be examined to correct clerical errors in judgment or orders to determine the meaning of words used in a judgment or order." In other words, from a formal record perspective, a calendar notice, a docket entry is inherently unreliable, and we're not obligated to rely on that. What controls is not docket entries. What controls a lawsuit are the pleadings from the parties. And here, both parties consistently from day one, and indeed even to this day, have asked for a jury trial.
So you're saying that the parties are not bound by a trial notice? Is that what you're saying? That because that is different than a docket entry, isn't it?
But the calendaring entry, I guess, I think in my view, Your Honor, and maybe I'm misspeaking about the court's internal procedures, but the entry on a particular calendar is a ministerial act carried out by the clerk.
That's not the point I'm making, is that the notices that were sent to the parties, I believe all said, and we can look that up, that this was going to be a non-jury case.
Your Honor,
Is that correct, Ms. Bennett, or not?
I'm sorry, I want to make sure I'm understanding the question. Whether the trial notice went out?
Now, whether or not the trial notices indicated that it was going to be a non-jury case.
Yes, Your Honor, that's attached to our motion as Exhibit A. The court sent one notice and it did indicate that it was a non-jury trial. That is the one and only notice that's been issued by the court.
But that's not, Mr. Cradaville, that's not a docket entry, I don't believe, is it?
I would concede that is not a docket entry. And I think we would again just say this falls under the broad category of excusable neglect in not paying the jury fee when both sides repeatedly and consistently demanded a jury trial. There was this technical defect that neither side timely paid the jury fee.
What case law is there about excusable neglect when it comes to payment of jury fees? Because I don't remember that being discussed in any of the cases that we've talked about. Is where,
Your Honor, it's fundamentally a question of prejudice. In this case, prejudice to the plaintiffs. And
doesn't prejudice really go to the issue of delay, not really the issue of why? I mean, all the cases, and I haven't read all the cases, I just read a few of them, but it seemed to be the issue of prejudice is whether or not the party opposing moving into a jury docket was going to be prejudiced by the delay and like some of the cases, jury available that day and they just went with a non-jury. In this case, we have a very different situation where we could have a very, very significant, again, I don't know for sure how long the delay is going to be, but it could be, according to the Opposite Court Administration, delays of up to 3 years. I don't think it would be that long, to be honest, in the 68th. I think we're going to move it a little quicker than that, but it's going to be a significant delay catching up, especially on a 2020 case. But are there any cases that talk about the issue of excusable neglect in any of the briefing that you guys have done?
Your Honor, I'm going to answer that question momentarily, but I think Your Honor just put your finger on the key issue here, which is the issue of prejudice and why. You're right, prejudice controls. And the reason there's no prejudice here is they are judicially stopped from asserting that they are prejudiced by getting what they want, what they have requested, what they have asked for from this court, not once, not twice, but 3 times, and that we also asked for, and that's a jury trial. So the issue of prejudice, you're right, it's whether the party opposing the jury trial, opposing the continuance as well in this instance, would suffer prejudice if a jury trial occurs. There is no prejudice here because they have asked for a jury trial. They cannot say they are prejudiced.
I guess the cases I've read don't really talk about that. They talk about whether or not there's going to be a significant delay, whether or not, in this case, there's going to be, you could either try the case that one of the next 2 weeks, and in my view of the docket, and again, things could change if for example, if the Delta variant turns out to be much more serious and we shut down jury trials again, we could get this case to I guess we would get it to a non-jury case. If we put it on a jury docket, I don't see any way it's going to speed up because of the Delta variant. It would delay it even further. So yeah, the cases I've read indicate that the issue of prejudice goes to the issue of timing of the trial. And we have an option of either trying this now, the next 2 weeks as a non-jury case, or trying in a significant period of time from now. I would guess well over a year, maybe 2 years, given the age of the case, but I don't know for sure.
And Your Honor, I think the reason
really an issue of timing of the trial and not.
The reason the cases don't speak to that, Your Honor, is that we're in a unique situation here. Unique as far as I can tell. I haven't encountered an equivalent case where both sides in their pleadings throughout the case have asked for a jury trial. And now at the 11th hour, if not the 12th hour, one of the parties has elected to change course. That's why I think, Your Honor, there's not a case directly on point. And that's why I think there is an estoppel.
You're arguing there's some kind of estoppel issue. Is that kind of your issue? Do any of the cases discuss the issue of estoppel?
Your Honor, may I address that briefly?
Sure, go ahead.
We have looked at all of the cases cited by the defendants, and none of them address the estoppel issue. As Mr. Cradaville acknowledged, our jury demand has been withdrawn. If he's saying the word jury is still somewhere in a prayer, I won't dispute him on that, but our jury demand has been withdrawn. To the extent that the word prayer is still in there, I'll withdraw that on the record. There is no question that we do want this to be a bench trial. Even in the record transcript that we talked about earlier this week, dating back to December, Your Honor has acknowledged, oh yes, these are the cases where there's the jury waiver issue. Also, just quickly, I want to address the question that Your Honor asked about whether or not there's any cases that we've cited in which a court affirmed this, and there is one. It's a 2020 case out of the Dallas Court of Appeal out of Judge Montgomery's court, and it's Mays versus Hunn, Hunn. And in that case, Judge Montgomery was affirmed, and the Dallas Court of Appeals says a trial court does not abuse its discretion by denying a request for a jury trial that does not comply with the requirements of Rule 216. And what happened in Judge Montgomery's case is 2 days before trial, a party demanded a jury and paid the fee only 2 days before, and she denied that request, and the Dallas Court of Appeals in 2020, December of 2020, affirmed Judge Montgomery's decision.
Mr. Cradaville, how do you distinguish that case?
Your Honor, the consistency of the jury demands from day one by both parties continuing through what they filed on June 25th, 2021, all of the live pleadings ask in writing for a jury. And I would also direct the court to the Dallas Court of Appeals opinion from about a year ago in Ray, and I'll probably butcher the pronunciation here, but Saki, S-A-K-Y-I, cited in our papers, which speaks to the need for flexibility and leniency in consideration of continuances during the COVID period. So we think the combination of them not being able to say that they're prejudiced by relief by a procedure that they have requested, and indeed until moments ago, until this withdrawal in open court of the jury request they have made. Here, it's not a late jury request. The jury request was
but doesn't late. To be put on a jury docket requires two things: the payment of a fee and a prayer. It doesn't just require a prayer, correct?
That is correct under Rule 216, Your Honor. But the consistent theme, and I think Your Honor's already recognized this in the cases we've cited, is that under Rule 216, even though it has that shall language because of the sacred nature of the right to a jury trial in Texas, guaranteed not once but twice in the Texas Constitution, only one of the state constitutions of the 50 state constitutions to contain two separate guarantees of a jury trial, that shall is not as strong as a shall normally is, and that whereas here there's not prejudice, and there's not prejudice because they're getting what they asked for and what we asked for, a jury trial, there is an exception to the
and let me make it 100% clear. If the parties agreed to this continuance and agreed to put it back on the jury docket, I would be perfectly okay with that. But it's my understanding, Ms. Pettit, is you are not consenting to putting this onto a jury docket or continuing the case. Am I misunderstanding that?
Your Honor, we are not agreeing to put it on the jury docket, but as I said on Monday, and I'll state again, if we want to agree to Your Honor's only other bench trial, which is December 28th, and the consolidated case, we are perfectly in agreement to allow them to have that December date, but that's not what they want. It's not the continuance they're seeking. Otherwise, they would agree to the December 28th date, which we've agreed to.
Let me just make sure I understand Your Honor's and Ms. Pettit's proposal there or statement there, that if trying to separate out, as I did in the opening of my remarks, the continuance from the jury issue, if a continuance were agreeable on the non-jury docket, that's something that that Ms. Pettit and the court are open to.
What I had said before is that we can kill two birds with one stone. I have 40 other cases at least, and Rhonda can correct me on this, is my recollection. It's over 40, but it changes from day to day because we have so many cases that we're putting onto that docket because it's only non-jury week. But if we could take care of both of these cases and not have to, that would take away 2 jury trials that are going to take probably 3 weeks or so. We can get those tried, both of the cases tried that 1 week. I would specially set them simply as a matter of judicial economy because these cases are going to take a while. But by the same token, if you guys don't agree to it, then I'm perfectly okay with just discussing it in the context of this. I have a number of other cases. What I'm inclined to do at this point, Mr. Cradaville makes a compelling argument about this estoppel issue. I don't remember that being briefed. I'm going to do something probably neither side's going to like. I'm going to move this case to the 13th for now. I'm going to let Mr. Cradaville and Ms. Pettit brief this estoppel issue after they finish their mediation because Mr. Cradaville has made, I think, a compelling argument, but I don't remember it being discussed at all in any of the briefing. And so, but it's 37 cases. Okay, she says I have 37 cases set on the 28th, but we will put you in front of all of those cases if we can combine the 2 cases together, put them both there and avoid, and usually I don't mind jury trials. I love jury trials, but we just are swamped. We just have so many jury trials. I don't know how we're going to ever catch up. And if we can take care of 2 of them on our non-jury docket and get those, finished in a week, that'd be something the court is willing to do. But I'm not trying to force anyone to do anything. I'm just trying to give options that would maybe help out both sides. But for now, what we're going to do is move you to the 13th. I want you both to brief this issue of estoppel, and I may move it again if Mr. Cradaville is able to come up with some good case law on this estoppel argument, which I do think is probably the most compelling argument that he has. But I don't see that fleshed out in the cases. And so if there's something else that needs to be researched on that, I do want to note again that if there can be an agreement on some other way to do this, I've also offered, I think, maybe not with this exact set of attorneys, but definitely in this case, is if you guys wanted to agree to try this with a visiting judge, either as a jury or non-jury case, I'd be okay with that. Maybe Judge Jordan or someone like that. I'd be happy to do that if both sides agreed, and you'd have to pay for the court reporter, but I'd willing to let it come out of my visiting judge fee or not fee, visiting judge fund. Not my fund, but the state fund, as long as there's Judge Wheelis allows it. But I'd be happy to set it on a date of y'all's choosing with a judge of your choosing, if you guys are willing to pay the fee. I'm not trying to make this difficult. I feel as a trial judge, we're in an almost impossible situation right now with this incredible backlog, and so we're just trying to figure out ways to ease the backlog. And so this is one option. Does that make sense?
Yes, Your Honor. Just to confirm, the 13th is the non-jury docket. Is that correct?
It'll be on the non-jury docket for the 13th, which is, I want to make sure that's Tuesday, July 13th. July 13th, correct. And it'll be a non-jury case for now, but Mr. Cradaville, and I'm happy to set another hearing date on this if you want me to, maybe for next Friday, if that works for everybody, or next Monday, but that seems like it'd be too quick. Or would Mr. Cradaville, would you rather me just keep it on the 6th and we can?
No, Your Honor, I very much appreciate Your Honor giving us the opportunity to submit additional briefing on the judicial estoppel issue, and we would be happy to have another hearing at the court's convenience next week, whether that's on Monday or Friday. We will find a way to be there on either day, whatever works best.
Ms. Pettit, I do have a record now. I may be not remembering this correct, but do you have are you available on the 13th, or did you say you had a trial?
No, Mr. Urtiaga and I are both going to be separately out of town that week, but Of course, if Your Honor orders us to be here, we will be in trial and both cancel our separate trips.
I feel bad about that. When is your trip scheduled for?
Give me 1 second. The 10th through the minus the 15th. I think David's gone through the 16th.
The 10th. When is that?
That's over the weekend. That's Saturday.
It's just, yeah, because starting the 19th, I'm swamped. That's the, do you have another, I don't want to ruin your trip, but I also don't see another way to do this.
Well, we will, we'll make it work, Your Honor. I personally don't think Mr. Cradaville's argument will be persuasive, because to the extent he's saying we waived it by having the word jury in a prayer, well, I'm going to fix that in 10 minutes. So that issue will be moot by the time that we're back. But that said, we will be here if the court orders us to be here for trial on the 13th.
Well, don't cancel your trip yet, because I don't want to, when is you leave on the 10th, so I want to have this hearing before the 10th.
Sure, so next Friday would be fine.
Then Friday the 9th. And you have mediation this afternoon?
Yes, Your Honor.
Yes, Your Honor.
Is there any chance this case could settle? Some of the other ones have settled, right?
On that point, Your Honor, if both sides are reasonable, I think we can get it done.
All right,
I think that was a jab by Mr. Silvas at me.
No, if both sides are reasonable, we'll get it done. We're motivated, Your Honor.
Let's hope both sides are reasonable. I'm a little confused. Do you represent Mr. Delgado in this, Ms. Pettit?
No, Your Honor, I represent Mr. Holm and 5 Points Holdings.
Okay. All right. These cases are also, anyway, interesting. All right. Well, let's go ahead and reset this. Rhonda, go ahead and reset this to the 9th at 9 o'clock and give me the briefing by, let's say, next Wednesday. Both sides on the issue of estoppel. Don't do any of the briefing until you finish the mediation. Hopefully it'll settle. And good luck, guys.
Thank you, Your Honor.
Thank you,
Before I
Judge.
log
We really
off, I do have
appreciate
to say hi, Mr. Henley. Thank you, Judge.
Good to see you guys.
Thank you.
Take care, Your Honor.
Thank you, Your Honor.
Okay, we have quite a few hearings set kind of all at the same time. So let me go through these one at a time. Okay, so I'm going to start off with, because we have this Angel Sword case, but we have a couple of hearings with that, so I'm going to hold off on that. Let's start with Canterbury Cove versus Thv Construction. Anyone here on that case?
Morning, Your Honor. Sean McCafferty on behalf of Canterbury Cove. Good to see you.
Good to see
Scott
you.
Hayes on behalf of the defendants.
All right, let's proceed with this case.
Right, Your Honor, this is an agreed motion for continuance. This is the first request for a continuance. I was hired in May to substitute in. There was a brief mediation right after I was hired, which unfortunately wasn't successful. And this is just to adjust some of the deadlines to accommodate the need for some finished discovery and expert deadlines. There's a proposed agreement to move the trial to November, so not a very long extension request. But that's what's before the court. And it's agreed.
So this is the issue, and I'm happy to move it, but you kind of got a sense of it from the last hearing, is that as a non-jury case, and I don't mind it being a non-jury case, we don't have any non-jury dockets between now and December 28th, and so and just as a newer case, is it set? When is it set for trial now?
Tuesday.
I could try it on Tuesday. I mean, it's the next 2 weeks I kind of are looking at as my last two really non-jury weeks until December 28th. After that, it gets to be much more challenging. And so I'm happy to move it. If you guys both understand that the delay could be significant, if it's a non-jury or if it's a jury case, because both of those are going to be delayed because of the backlog. But I would be able to try it the next 2 weeks if you want to do that. If you don't want to do that and you want to move it, I'm okay with that. But I just wanted to kind of, I don't know how much of the previous hearing you heard. We are, the Office Court of Administration is estimating our backlog, not my court in particular, but just generally across the state, 3 years. It's going to be significant in all the courts, including mine, just the number of cases that are, the sheer number of cases. I tried 2 jury trials on my date last week, back to back. We picked 2 out of the same panel. People who know me here know I'm going to work hard to try to get this backlog done. I just want to be transparent that if you do move it from this date, it's probably going to be a significant delay.
Yeah, I understand it as much as I'm sure my client does not want any kind of significant delay. I mean, I think from my perspective, the reality is there's a little bit more work to be done before it's actually ready for trial. I mean, I've only been in the case for about a month or so I know that we need some expert issues to be resolved, probably, and a little additional discovery. I know Scott probably wants some as well.
I agree, Your Honor. Yes.
Unfortunately, I know you'll work hard, but unfortunately, I just don't think we could get it ready to talk to you about it on Tuesday.
What about on the 13th? Would you, because starting on the 19th, jury trials are coming back. Could you get it done? I'm not trying to force you to do anything. It's a new case. I'm happy to move it, but I could move it 1 week, but then after that, we're just flooded.
Yeah, unfortunately, I don't think so, Your Honor.
And I agree. I think we just have too much still to do.
Do you want me to set it on November on the non-jury docket, or do you want me to send it on December 28th, or when do you want me to set it?
Well, we proposed November, but based on what you said about December being your first available non-jury.
Now, again, I don't know if you all heard me talk about the way I call my docket. This is the way I've done it since I first started as a judge. Is typically we'll try my oldest jury trials to my newest jury trials, and then after all the jury trials are done, from my oldest non-juries to my newest non-juries. And so, if you're on the new, you're a pretty new case either way. So you'd be either at the tail end of the jury docket or on the beginning of the non-jury docket, depending on if you want to pay a jury fee. If it's a non-jury week, then you're just competing with the other jury cases. We currently have 37 cases set, non-jury cases set on December 28th. So that's the situation. So we'll do whatever you guys want to do.
Yeah, I think we go ahead and set it for November and see how the case shakes out.
Yeah, I agree with that.
Okay. All right. When do you want to set it? And you said in November or December? November?
Yeah, I think the proposed scheduling order has is it November 9th, Scott?
November 9th.
Okay. Rhonda, go ahead and move this to November 9th. And just wanted to kind of let you know what was going on. But if you guys just be aware that it could be a significant delay. So, but we'll be glad to comply with your wishes. So, all right. Thank you so much, guys. You guys are excused. Be safe.
Thank you.
Thank you, Judge.
Your Honor.
All right. Our next case is Luther Preston Center versus Polaris Operating LLC. I'm sorry, that's wrong. Wen Oliver versus Juan Andres Cuellar. Are both sides?
Good morning, Your Honor.
Good morning, Your Honor.
Good morning. All right, let's go on the record on this one. DC 1715831, Wen Oliver versus Juan Andres Cuellar. Counsel, make your appearances.
Jim Sadley for the plaintiff, Oliver.
My name is Brett Myers, Your Honor, on behalf of the defendants.
Was there somebody else who said something besides Brett Myers? Okay, let's go ahead and proceed.
Your Honor, this is a resumption of our earlier discussion this week on I'm getting an echo somewhere, Your Honor.
Who's going first?
I'm not sure why.
In any event, Your Honor, this is a continuation of our earlier discussion this week regarding the reliability of the experts that have been designated by the defendants. There's really two issues. Number one, is Mr. Money's analysis in this case, is it reliable? Or presumably the issue of whether he's qualified or not has been resolved with respect to the Allstate opinion. But as to whether or not his opinion is reliable, if it's based on methodology that is reliable, is an issue that we need to address today. And then the second issue, Your Honor, is with respect to Dr. Hill. And again, I don't think his qualifications are in question, and I don't think that the relevancy of his opinions are in question. The question is whether Dr. Hill's opinion and work in this case is reliable and based on scientific method and accepted principles in his field.
We also had a second expert. We had three other experts, I thought, or has that all been resolved?
We did, Your Honor. We had two doctors who also testified about reasonable and necessary medical expenses. But as the court may recall, there was their methodology or their opinions, at least in part, rely on the work that Mr. Money did with respect to his analysis of the Fair Health database.
And there's also a liability expert or biomechanical expert as well, correct?
That's Dr. Hill, Your Honor. Dr. Hill is the biomechanics expert.
All right, response, Mr. Zadie.
Yes, Your Honor. May I use the share screen?
You may. Just give me 1 second. Go ahead.
Thank you. My opposing counsel is correct. We've focused mainly on the methodology by Mr. Money because that is what's used by each of the medical billing experts. In this, it's the same method across the board. And as a preliminary matter, an issue that I didn't raise properly in my last argument was that all the data is being collected by MedCost Contain. They have their own billing experts that put together the reports that are then relied on by the doctors and Mr. Money in issuing their opinion. Well, that makes those consulting experts whose opinions have been reviewed by a testifying expert. Under the disclosure rules, we're supposed to be provided information about those consulting experts. At the very basics, the qualifications and their name. In this case, because of the intentional methodology created by MedCost Contain, those people are hidden from us. We have no idea who these consulting experts are, what their qualifications are, if they're in any way qualified to pull coding correctly or appropriately. It's not as simple as inputting a CPT code and getting a number set out. There are modifiers and exceptions to the modifiers that are built into the system. Moving beyond that, discussing the methodology by MedCost Contain, I just wanted to highlight a few things from the deposition. First, as we established in the last hearing, the definition of a reasonable charge is based on billed charges. That's used across the board and is agreed by the physicians in this case. Well, MedCost does not provide any data on billed charges. Here's the deposition of Greg Money, where he says exactly that. We don't give any opinions on what amount should be billed. We go on to discussing his opinion specifically, and he would say he is not offering that type of testimony. He says it's never been an area that I've concerned myself with, nor has ever been an area where I've been asked to give an opinion on. And this is why I think we are not done with the qualifications argument, because when we're talking about the billed charges, which is what we should be talking about, Mr. Money will admit that that's not an area he's ever concerned himself with. So how can he be qualified? Additionally, the experts themselves will say that they are not offering opinions on the billed charges. Here's the deposition of Dr. Patel. There's no data in your report or your controverting affidavit related to the charges, but there is related to the reimbursement rates. Yes, that's correct. That is the same across the board. That is a methodology that is employed by MedCost Contain. That is the data that they provide to every expert in this case that opines on billing. And then finally, I have one more excerpt from Dr. Duvall. I pointed to similar language in the last hearing from Mr. Money. This approach is inherently not objective. They will never, ever, ever opine that any charge is too low using this methodology. Even when their data and their experience tells them that a charge is too low, they will never offer that opinion. And for those reasons, Your Honor, we say that this approach, this methodology is not reliable. We're not talking about the same things. We're not comparing apples to apples. These are apples to oranges. The providers admit it. Mr. Money admits it. He will say time and time again, I am not talking about oranges. I'm talking about apples. But we are presenting oranges to the jury. Our experts are presenting oranges to the jury. This is a case about oranges. This is not a case about apples. And so for those reasons, Your Honor, in addition to what we've pointed out in our motion, the deficiencies in disclosing who is actually providing the expertise here, we believe that the MedCost methodology is not reliable and should be struck in this case.
Okay. Mr. Myers?
Yes, Your Honor. Mr. Money is here and he's prepared to testify about his methodology and about his background and his experience. What I would point out to the court that Mr. Money is going to tell you is that the data that he looks at is the non-discounted charges. He looks at the situation where there is no agreed upon rates, and then he takes the non-discounted charges that the medical providers receive for treatment in the Dallas-Fort Worth area. So we're not talking about a situation where there's a contract between the provider and the insurance company. We're talking about a situation where there is no agreement. And then Mr. Money takes the non-discounted charges, which is the most valid information available as to what providers in the Dallas-Fort Worth area are actually receiving for the medical services they provide. Mr. Money is here. He can provide you with his background, his training, his experience to satisfy the qualification provision. He can then testify and provide you with his analysis, how he goes about doing that analysis, how the analysis that he uses is accepted and reliable.
I'd rather you just submit it as his deposition. I just don't have time to hear that today. I have too many other hearings. So, but if you have the deposition, you said you've taken his deposition, or you have an affidavit from him that I can review.
His deposition has been taken, but if the court would allow, then what I would like to do is prepare an affidavit for him to execute that describes what he would have testified to today.
Mr. Zaidi, I think that's only fair.
That's fair, Your Honor, but the testimony is out there. We know what he's using. I mean, I can show the court the data from his deposition right here. For example, I had highlighted this in the event that Mr. Money testified, because that's a deficiency that I would address with him. But for example, when we go to his explanation of codes, you can see that some of the values are being determined by adjusting Medicare rates. Some of the values are being adjusted by Texas workers' compensation rates. Some of the values are being adjusted using different reimbursement schemes. These aren't going to change whether he signs an affidavit that says this is his methodology or not. This is his methodology.
Well, Your Honor, certainly then Mr. Money would be entitled to explain, and the defendants would be entitled to explain to the court why Mr. Money is using each particular rate. That's not an issue that came up in the deposition. It was never asked. And so in terms of developing his qualifications and his methodology, I think it's certainly appropriate for the court to either hear from him today or to accept an affidavit that describes that process.
One of the things, and I don't know the timing on this, was the deposition taken before or after Inrail State came down?
It was taken before, Your Honor.
It would be before, Your Honor.
Mr. Zaidi, I mean, I'm not ordering this, I'm just asking a question. Would it make sense to take his deposition again in light of Inrail State or not? Or because I have a feeling that this case is going to set a precedent, at least in this court, about how we deal with this, because I've struck Mr. Money on many different occasions prior to Inrail State. I think it's important to hit this type of expert. We have to really take a look at whether or not that's the proper ruling post Inrail State. And so I think it might make sense to kind of fully flesh this out. But Mr. Zaidi, what do you think?
Your Honor, we did provide supplemental briefing on Inrail State. And while it does offer, I think, a little bit of guidance on what constitutes qualifications under 702 in this area, it is completely silent on reliability, and in fact says that reliability, the Dahlberg-Robson standards, are not what the court was looking at in Inrail State. And we provided some briefing to the court, I think filed yesterday, that laid that out.
So what I'm asking you is, this is what my concern is that I think Mr. Myers is right. I think it's only fair to him to be able to prepare an affidavit that, since I don't have time to hear Mr. Money's and any other experts' testimony today, I wanted to give you the opportunity to take Mr. Money's deposition again in light of NRA Allstate if you want to, but I'm not going to require you to do that. But I do think that it might be wise. But again, you're experienced counsel, and so it's just this is going to come up again and again. Again, I anticipate, and probably in even more cases, and so. Your firm, I know, will fully flesh this out. You guys are very, very thorough. And so, anyway, do you understand what I'm saying?
I understand what you're saying.
Do you want to take his deposition again in light of Allstate, or do you want to just let Mr. Myers do an affidavit and then fight it down? Or do you want to decide after you see the affidavit?
I think I would need to see the affidavit, Your Honor. I feel like we really did flush out the methodology. The deposition was hundreds of pages. We went probably 6 hours the entire time, talking about just different methodologies.
When is this case set for trial? On August 17th? Is that right?
Yes, Your Honor.
Mr. Myers, how quickly can you get me an affidavit from Mr. Money?
How about, it of course depends on Mr. Money's availability, but I would certainly think within by Wednesday of next week.
That's fair. And then Mr. Zaidi, within 24 hours of receiving the affidavit, you're going to need to decide if you want to take the deposition. You want to ask Mr. Money if he's available to do a deposition, and it would just be a supplement if you feel like you need it.
I can do that, Your Honor.
So let's reset this hearing. Let's see, today is, what is today? Today's the 2nd. And the trial setting, okay, so do you want to reset this to like the 23rd maybe?
I'm available that day, Your Honor.
Our hearing.
I'm available that day, Your Honor.
Mr. Zaidi?
I'm available that afternoon, Your Honor.
That's a little tougher. How about the 30th in the morning?
I will be out of the country, Your Honor.
Okay, how about August 6th in the morning?
I'll still be out of the country, Your Honor. I apologize.
Could you get this ready by July 16th?
Your Honor, I'm actually out of state on that day.
How about, when do you leave out of the country, Mr. Zaidi?
I leave on the 29th, Your Honor, and I am back on.
How about July 26th? How about July 26th?
Yes, Your Honor, that works for me.
I can make that work, Your Honor.
All right, let's do July 26th. Rhonda, reset this to July 26th at 3 o'clock and give me some supplemental briefing on this, okay?
Yes, Your Honor.
All right, and then Mr. Myers, I want to make it
Your
clear
Honor.
that if Mr. Zaidi wants to take Mr. Money's deposition again, he's going to be allowed to. I mean, it's not an order, but I'm just giving you direction.
Of course. That's fair, Your Honor, of course.
So, all right, just get me an order on this, Mr. Myers, about the allowing the affidavit and then everything else we've discussed, and share that with Mr. Zaidi. Make sure you say on the order that this order was heard on July 2nd, 2021, instead of on this date, and get that emailed and e-filed as well. Emailed to my court coordinator and e-filed as well. All right?
Your Honor, with respect to the other expert, Dr. Hill, do you want to move it to that date as well, or do you want to address that this morning?
Let's move it to that date as well.
Yes, Your Honor.
All right, thank you, guys.
What time again, Your Honor? I'm sorry.
If I may.
At 3 p.m. that
3
day.
p.m. Yes, Your Honor. Thank you, Your Honor.
Society, you were going to say something?
Your Honor, could we get an hour for that hearing?
Yeah, I'll do my best. It'll be in the afternoon, so it'll be a little bit easier. So, yeah, we should be able to fit you in for about an hour.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Okay.
Are we excused?
You are excused. Thank you so much.
Thank you.
Okay, I believe that, is there anyone here on the Zubarak versus Gonzalez case? Anyone here on Perkins versus Moore? Perkins v. Moore?
Yes, Your Honor. Scott Word is here on behalf of Gia Perkins.
Reginald Moore is here, sir.
All right, let's go ahead and proceed on this. Go. Who's the plaintiff? Who's the attorney on this? I heard you're muted, sir.
My apologies, Judge. Can you hear me now?
I can.
Okay. Yes, Your Honor. I represent Gia Perkins. This is a breach of contract case. Mr. Perkins is representing him. I'm sorry, Mr. Moore is representing himself pro se. He did file an answer. Discovery was propounded upon him back in March. He failed to answer. We've also noticed his deposition. He failed to appear. Based upon his failure to answer those discovery requests, this motion for summary judgment was filed. His admissions are unanswered, so therefore by his deemed admissions, all of the elements of our causes of action are established. This motion for summary judgment was filed and properly noticed on June 10th, and Mr. Moore has failed to file an answer, failed to file a response to the motion for summary judgment, and so we would just ask the court to enter judgment on behalf of the plaintiff according to the motion.
Mr. Moore, what is your response?
Well, I asked to meet with Mr. White to try to reschedule everything. I had an attorney at the time that we filed everything, but I don't think everything was handled the way it should have been handled because of how the contract was done. I'm not denying that she didn't invest in order for us to do some construction. But I am saying, and I didn't have a problem with paying her funding back. And the agreed upon amount was she just wanted the amount that she invested back, and we agreed upon that. All that information was submitted to Mr. White, but I guess he just overlooked it or did not present it, along with the attorney that I had at the time, submitted it to him also. So I'm not about not trying to pay her what she invested, but the amount that we agreed upon in the contract, because we did actually start to purchase things to start to do some construction, and she signed the land back over to me. So I'm not about not paying her like we've already discussed, and I just wanted a little bit more time to come up with the funding to go ahead and get her paid. So it's not that I'm not trying to pay her, just wanted a little bit more time to go ahead and get the money together to pay her what she actually invested, because there was no money made on the investment. But we did purchase the land, and she signed the land because we started a company together, and she signed the land back over to me. So I would love to pay her money back. Just want a little bit more time to raise the capital to get her money back, and whatever the fees is that the attorney is asking for. So that's pretty much it on my end.
Response?
Yeah, Judge, this is pretty simple. One, he didn't file a response, but two, this is his MO. This is exactly what he does time and time again with my client. Just try to delay things, try to say we have an agreement, try to say this, try to say that, but nothing's ever done. And so at this point, Judge, we just need a judgment so that we can start collection efforts on that judgment.
Well, if that's the case, why would, if it was not that I wasn't trying to pay her, or the investment was not done, why would she sign the land back over to me when we actually went in together about the land? So I have no problem with paying her money, and that's not my MO. So I'm not gonna let you or anybody else try to dictate or tear down my character about what I do and what I don't do. I still wants to pay her her money, but since there wasn't any money made on the deal, and the land was purchased, and she signed the land back over. So how is it that I'm not trying to pay her her money?
So Mr. Moore, this is Judge Hoffman. I'm not sure
Yes,
if you
sir.
can see us or not, but essentially what we have here is a summary judgment, which is they're attempting to request to get a judgment against you. Under the rules, if they file a valid summary judgment, then you would have to file the response at least 7 days before the judgment. And so really under Texas law, I don't have a whole lot of choices here other than to grant the judgment. Now understand that if I grant the judgment, you still have time to pay it. They're going to have to go through collection efforts, which takes time. And that would give you time to be able to, do what you need to do to raise the money to pay off the amount that you owe. I'm not sure if you
Yes,
can
sir.
hear me,
I
Mr.
understand.
Moore.
No, sir, I understand that, sir.
All right, well, great.
I
Well,
understand.
thank you. Mr. Ward, go ahead and send me a judgment, an order on the summary judgment, and make sure that it states that the hearing was held on July 2nd, 2021, and you file it with the court as well as email it to my court coordinator, okay?
Right. Yes, Your Honor. The proposed judgment was filed yesterday, e-filed, but I will email your coordinator today.
If you could put on the version well, that's fine. Just go ahead and email it and just say that this is what the judge ruled on in the email. So, anything else today, guys?
No, Your
Thank you, guys.
No,
You guys
sir.
be safe, okay?
Thank
Thank you, Mr. Moore. Good luck.
All right.
Okay, our next hearing, I believe, is on the Angel Sword case. Anybody here on any other cases beside the Angel Sword case?
Your Honor, this is Boyd Mouse on the Luther Preston versus Polaris case.
Worthy Walker also here on that case.
Okay, it's that. Okay, so which case are you here on?
Luther Preston Center versus Polaris Operating LLC. I think you mentioned it earlier when you were going down the list.
Okay. Let's see. Okay. A motion for continuance. Did we not? Okay, we didn't talk about this one yet. All right. So you guys are set for trial when?
July 13.
Okay, so the main reason I wanted to have a hearing on this, and I believe it's agreed to, right?
It's unopposed, yes.
So this is the situation is, we are, as you know, that Dallas County has not, Dallas County has not had jury trials except for very limited in the last month and a half, for over a year and 3 months, longer than that actually. And so starting on July 19th, we're going back to regular jury trials. And so it's going to be very difficult for me to try non-jury cases and even really newer jury cases. So if you want this case to be tried anytime soon, I can try it on the 13th. It's kind of my last date before the flood of jury cases come in, and really will push this case quite a bit. And so I wasn't sure if there was a way you guys could get it ready by the 13th so that we could try it and get it off the docket, or if it really is something that's impossible to move, and you guys understand it could be, you know, quite some time, a year, 2 years, 3 years before we reach this case.
Your Honor, our issue, this is Boyd Mouse. I represent the defendant, Polaris Operating. I have one of our key witnesses, Mike Chisty, has a family vacation right during that week, that week in July. It's previously scheduled. And so that was the basis for the motion. I know we run into a lot of vacations and whatnot this time of year, but that was the
Could
basis.
y'all do next week instead? I mean, would that work? We could try you next week. It's the next 2 weeks we can try these non-jury cases. I'm just telling you, it's going to be a huge hassle for you guys if we don't try it now. Again, I understand family vacations and all that kind of stuff. This is just, these are difficult times, and we just have very limited judicial resources. So if you can try it before the 19th, if you're ready to go, I'm willing to kind of work around your schedule to get, how long would this case take to try?
I think 1 day bench trial, Your Honor. It's probably going to be pretty tight. We've got we're sitting at mediation right now as we speak, Your Honor. We've been putting off some deposition discovery. So we go to mediation. We'd have a few depositions to take next week. And so I don't think that's going to be possible. I've talked to my clients. I was listening to Your Honor earlier today. You'd repeated that same thing about the non-jury, and I spoke with my clients about that. They're okay if we have to punt this down the road. We'd rather not, but under these circumstances, my client is fine if we have to look for another date sometime down the road. Again, I think it's a 1 day bench trial. I don't think it would take more than 1 day.
Who's your opposing counsel, Mr. Walker?
Yes. Judge, as much as I would like to try this next week, I have a similar issue that my clients will not be available next week because of the holiday, and so that just won't work for us. I am sensitive to the fact that this could get kicked down the road quite a bit, and I'm not happy about that. However, I would like to say
what if we did this? Your clients are going to be on vacation, but we can handle this over Zoom. Couldn't they just appear via Zoom? I'm on vacation right now. So, I mean, if I could do this, I'm sure your clients can do it. Is there a way to do that?
I would have, unfortunately, I don't have all of them here, so I would have to check and see. I don't know the answer to that as I sit here.
I don't either, Your Honor, with my one guy that's on vacation.
One thing I wanted to ask, Judge, is I heard you mention earlier that there was a possibility of a visiting judge or an associate judge or something like that. You know, we probably wouldn't be opposed to that, since, I mean, this is going to be a bench trial the old-fashioned way anyway. So, you know, I think the primary problem that we had in scheduling was that on my side is that I've got two-week trials both in August and September, which really are just going to make it difficult to do anything in those months. That said, we all saw a window in October, and we were wondering if maybe that's a possibility.
No way. Not in a non-jury. I could set you then, but I would feel bad because, I mean, the earliest I could set you on that December 28th day when I have 37 other cases, but you're a new non-jury case. We're just not going to reach you then. I would say maybe set it next summer. Would that work? At least we'd have a shot at getting to you.
If that's where we are, that's where we are. We may be amenable to an associate judge. I talked with Worthy on that, my clients, but if that's where we are, that's where we are, unfortunately.
No, I'd be glad to, it'd be a visiting judge. We don't currently have an associate judge, but we could do a visiting judge. I would be willing to take that out of the visiting judge fund if Judge Wheelis approves it, and I'd be willing to appoint pretty much anyone you guys can agree to, but you would have to pay for the court reporter. I don't have funding for that.
Okay.
Well, do you want to talk to your clients about all of this and then get back to me, or do you want to maybe we could talk about this on Tuesday at 9 maybe, or what do y'all want to do? Because I mean, once we move this, you kind of go into a black hole, I think.
I think I know with my client on vacation, I haven't had a chance to talk with him. We'd probably, again, lesser of two evils, we'd probably just opt for just resetting it on your docket, Your Honor, on that 28th, and then perhaps counsel and I can talk about a visiting judge if we want to try to get something on earlier.
Are you in mediation on this case right now?
We are.
Oh, right now?
As we
Yes.
speak.
Well, I'd prefer if you talk to your clients about this. I don't feel real comfortable setting this, and because usually if I set a case for trial in pre-COVID times, I set it when I think that there's at least a reasonable chance. If I set you anytime this year, there's just not a reasonable chance you're going to get reached. And so I would, encourage maybe next summer, or if you want to, on a case of this. And so I think you do need to talk to your clients about that to see kind of if this is what they really want, and tell them that I'm okay with them if they want to appear via Zoom. They don't even have to be here for the whole trial, just their testimony. I'm okay with that. It's not going to upset me at all. I can handle this all via Zoom. I'm on vacation. I don't know what their vacation plans are, if they're going to have internet access. If we could do this, times have changed. You don't have to be in Dallas to try cases. And so, talk to them. I would encourage you to talk to them about all the options, and maybe you guys will settle this today. You guys made any progress?
We're working on it. We're early.
Okay. Well, why don't you guys talk about it, and we'll see you back. Rhonda, go ahead and put them on the Zoom docket for Tuesday at 9 a.m. And by then they'll have had an opportunity to talk to their clients, and we'll make a determination. And I do want to say that there is a chance, I don't want to be difficult, but there is a chance that I won't move this. I don't want to, given the reason, what the rationale is, which is your clients are on vacation. I don't know that I can continue, that I'm 100% sure I'm going to continue this. So I might, once we talk some more, but there is a chance I won't be able to move this, and we'll go on the 13th. But I don't want to say that for sure, but I do want to take a closer look at what cases we have set on the December 28th docket, because we do have, according to Rhonda, about 30 something cases. So, all right, guys, good luck with your mediation, and we'll see you next Tuesday at 9. If the case settles, just let Rhonda know, and we'll put you on a DWAP docket, okay?
Thank you, Your Honor.
Thank you, guys. Good luck. Okay, now we're going to, you guys submitted some very good briefing on this, very extensive briefing on this case. Let me go grab my notebook on this, and I'll be. Right. Ms. Patel, okay. And Ms. Bright, did you get my message?
Yes, I did. Thank you.
Yes, Judge, thank you.
All right, let's go on the I don't know. Do you guys want a record on this? It's on Zoom, but we don't usually do summary judgments on the record. But again, if you want.
I don't think we need one on the summary judgment, Your Honor. I think the first matter set is a motion to quash that Mr. Ellis set technically before our summary judgments.
Okay, let's do that on the record. Let's go on the record on cause number DC 207334, Angel Sword LLC and Angel Sword Corporation versus Osana Watson. Counsel, make your appearances.
Good morning, Your Honor. Jeff Henley for plaintiff, or I'm sorry, defendant and third-party plaintiff, Oksana Watson.
Your Honor, this is David Vassar. I represent the plaintiff in this case, Angel Sword LLC.
Good morning, Judge. This is Michael Ellis. I represent third-party defendant Daniel Watson.
Okay, let's proceed.
Yeah, Your Honor. And a matter of due course, I think there's a couple of motions to quash that were set technically 10 a.m., 10:15. The one that I'm involved with, and I'll go ahead and start unless someone wants to jump in or the court wants to take them in another order. I represent third-party defendant Daniel Watson. I've been in the case 90 days, give or take. I think he appeared sometime in March. And pretty basic, straightforward motion to quash issue. I requested the deposition of Ms. Watson, the defendant and the third-party plaintiff, back in early June. We are currently set for trial on the July 27th docket. Asked for it in early June. 30 days obviously would run late June. I asked for some dates within the normal discovery time frame. Due to the short fuse, gave a week, said, please get me dates. We don't have a lot of time. Both got I got a response about the same time, messages crossed. I noticed the deposition for late June. Got a response from Mr. Henley offering the deposition for Ms. Watson in the second, I believe it's second or third week of July. Obviously, it causes me a little bit of heartburn because we're after any reasonable discovery period and we're right before trial. And my experience right now is I can't get a transcript in 10 days in most circumstances. But all that being said, obviously the 24th is not doable because we're a week after that. So we have two issues right now. Number one, I need a deposition. I've got, by my math, 25 days to trial. So I need a deposition as soon as possible. Number two, the issue is where's the deposition going to take place? I have asked that it take place in person. I certainly understand the current circumstances and don't want to belabor that point. If there's a fear of COVID-related issues, I understand. I would note, and I've had to fight this battle in other cases, if a party can't show up for a deposition in person, I don't think they can show up for trial in person either for the same reasons, just practical, so to speak. But really the response and the motion to quash from the defendant, third-party plaintiff, is more focused on a fear of the witness relating to my client being there and somehow intimidating, and there's allusions to fear of violence and those kind of things. I don't want to spend a lot of time on that, Judge. Several quick points. Number one, a fear of violence is not practical. I'll be there. Number two, I can assure you, my client's on the phone right now. It doesn't pop up on the thing, but he's on the YouTube watching this hearing. I can assure you, my client will be very aware of the rules and this court's view on misbehavior and depositions. And number three, there's remedies. If anything gets out of hand, every lawyer here, we all know we can find the court quickly, and Your Honor has been very helpful in depositions previously when problems pop up. So I just don't believe that's a credible concern that the witness is somehow afraid relating to her soon-to-be ex-husband being present in the deposition. It's his right. I'm not sure he's going to be there, but I think he might. And practically speaking, I would like the deposition in person for obvious reasons. We've all done great with video, but depositions take 2 to 3 times longer, particularly in charged situations. I just want to get this done and done quickly. We've already agreed to do it at Mr. Henley's office. So with that being said, practically speaking, if she can't appear in person, I don't think she can appear in person at trial. It's only reasonable. For whatever the reason.
Mr. Ellis, let me just ask this. So you're not asking for a continuance of this case?
I'm not right now. I'm late to the game. There are two other lawyers who've been in this much longer than I am. I just want a deposition so I can present some case, reasonably present my case at trial as needed. I'll let the other lawyers speak to continuance issues. I know we're now on a jury docket, and I've been listening all morning. I know how tenuous that is. We're a fairly new case, filed mid-2020, so it seems a little ambitious to think we're going to get reached in July, but I don't want to be presumptuous either. That's my pitch. I just want the deposition to advance the trial as fast as possible. If we're not getting reached on the 27th, I think we have more flexibility. Thank you, Your Honor.
Mr. Henley.
Judge, I think that there are a few issues. Number one is at the time of these discussions, before it seemed like this case was going to be to the bench and via Zoom. And then within the last 2 or 3 weeks, Mr. Ellis has made a jury demand and I believe has actually paid the fee. And so the dynamics have changed. My understanding was when Your Honor first put this matter for trial, I guess about 2 months ago or 2 or 3 months ago, it appeared that it was all going to be done by Zoom. And as a result, there was no reason to have Ms. Watson suffer a direct deposition, travel for it, and endure, having to sit near her ex-husband.
Where does Ms. Watson live?
Ms. Watson, as do the parties, they all live in Central Texas, which is what we've been complaining about from the get-go. She lives in Austin. Mr. Watson lives in Hayes County in a little place called Driftwood. But the fact is, none of these people are tied to Dallas County like Mr. Vassar, Mr. Ellis, and myself. And so I had suggested, well, since the trial is going to be via Zoom, or at least it appeared before, then go ahead and, she could submit to a deposition via Zoom.
So Mr. Henley, let me just ask this. Do you want this deposition to be over Zoom, or do you do you want it in person, or what is your?
Well, preference? I think that if this trial is going to be via Zoom, then the basis to have a live deposition is.
I don't think this trial is going to be via Zoom. It's going to be, if it's a jury, if there's a properly paid jury fee, it's going to be in person. And so just FYI, if it's, I don't know that those things are necessarily tied, but I think it'll be an in-person jury trial. If it's, now whether or not we be able to reach you guys on July 27th, I think is what you said, is pretty unlikely, but but we'll see. I guess my thought is you have two folks here, Mr. and Mrs. Watson, and I'm perfectly okay ordering it to be via Zoom. I'm perfectly okay ordering at this point to be in person. I'm kind of think it's up to you, Mr. Henley, what you prefer.
Well, if the 27th setting would, be more likely to occur via Zoom, then
it's going to be in person if it happens. So what, given the fact that it'll be in person, if assuming that it's the jury fees been properly paid and it's properly on the jury docket and you somehow get reached, it would be in person. There aren't going to be Zoom jury trials.
And so your question is preferring the deposition being live?
Yeah, do you want the deposition live or via Zoom?
By far, it would be far more manageable and being able to maintain her security better via Zoom. Just like I would prefer to depose Daniel Watson live, because I sympathize at some level with Mr. Ellis's underlying concern about the confrontation component that,
Wait, did you say you wanted to take Mr. Watson live or via Zoom?
No, I mean, I would prefer, obviously, always to take any deponent live. But the fact is, it would be very unfair for me to insist that I take his guy live and that he has to take her Zoom. So
yeah, what's good for the goose is, so if you say I want my person to be, are you trying to take Mr. Watson's deposition still?
yes, that would be something that we would insist upon, and we would be perfectly happy to do it via Zoom as well.
Okay, so we're going to do both depositions via Zoom. When can you guys do it?
Well, Judge, from my standpoint, I'd like it as soon as possible. I'd like it 3 weeks ago. I would note, again, we're talking, they haven't asked for Mr. Watson's deposition. So in advance of the 27th, I think we're well past any ability to take his deposition before trial on the 27th, just because they never asked for it. So I would need a little more time than that to address a lot of those issues.
When would you like to take her deposition?
I think next week is the absolute latest. Thursday or Friday of next week is probably the latest. And I'm still
available Thursday or Friday next week, Mr. Vassar.
I have a couple of hearings in the morning, but could, start at 10:30.
Mr. Henley?
I actually am available on the 8th or the 9th at present.
Check with your client. She's apparently on the Zoom.
She is. I know she works. She has a sort of an hourly wage job that she has been emphatic that she can't leave from. And I assume that that's probably what she's thinking right now.
Miss Watson, can you unmute and go ahead and turn on your video?
I mean, part of the issue, Judge, is Daniel Watson owes her about $40,000 in cash, and so she hasn't been able to survive. And when I mean the $40,000, it's like arrears. Mr. Vassar's shaking his head, but the fact is he was ordered to do so in the family law case.
That's down in Hayes County.
Mr. Henley, let's deal with the deposition. So can you ask Miss Watson Miss Watson, you need to unmute? Okay, so are you available next Thursday or Friday for a deposition via Zoom?
Absolutely not, because I'm working 6 days a week and my boss will never give me days free.
What is your day off?
My day off is on Sunday.
What time do you get off work?
So 10 o'clock. I have to be at work 10 o'clock.
You have to be at work at 10 o'clock in the morning?
Yes.
And you work until what time?
6:30. 6:30. Sometimes longer. It depends on the clients. So I cannot leave the store. It's a retail store and I need to make money because I work hourly. So I'm struggling. I have to work 6 days a week. I never take days off. I work like nonstop machine.
Mr. Henley, would you prefer to do the deposition starting at 7 in the evening, or would you rather do it on a Sunday? Or Mr. Ellis? I should really leave it up to Mr. Ellis.
Judge, I sympathize with the situation. I'll take a deposition whenever need be. My biggest concern is to have an effective deposition 3 weeks out from trial. If we do that, this is by video is going to take the full 6 and maybe some more, just because video depositions just take a lot longer. So I'll do whatever works for the witness and counsel. I'll make myself available.
Judge, I don't mind working on Sundays.
You want to do it this Sunday or the Sunday after?
Oh, I may be having a party this Sunday, July 4th.
Oh yeah, I didn't forget. Never mind. How about the 11th? I forgot it was.
I don't have anything set for the 11th.
Mr. Ellis?
Sure, 11th's fine with me, Judge. I would note that if we're going on the 27th, I don't know how she can be here for trial on the 27th if she can't appear for a deposition. Otherwise, I guess we'll cross that bridge when we come to it.
Mr. Vassar?
I'm free on next Sunday, yes.
July 11th?
Yes.
Okay. All right, Ms. Watson, we're going to go ahead and start this deposition, let's say at noon. That should give you a good 6 hours there. the deposition can be up to 6 hours long. That's 6 hours of time actually in the deposition, not 6 hours like noon to 6, but 6 hours of deposition time. I don't know if it's going to take that long or not. Have we dealt with the issue of the depositions now?
That's all I have, Your Honor, on that issue.
Mr. Ellis, go ahead and get me an order to that effect. Make sure that the order says at the beginning that this was heard on July 2nd. Email me the order, email my court coordinator the order, as well as e-filing. What's our next motion?
Yeah, we do have a couple. If you still want to have a court reporter and then do the summary judgments, the last things that got set with Rhonda, since we were the last ones, is we had a couple of motions to quash subpoenas out there, and she said, "Well, since you're last, we can set those also." So we can hear those now, or Mr. Henley and I have agreed that if you want to hear the summary judgments, he gets to go with his first because his is first filed.
Is the quash, is that going to be quick? What I haven't seen.
It'd be pretty quick, Your Honor.
Let's take care of that, and then we can let Tony go.
Okay.
Wait, is Tony still here? Yeah, there she is. Okay, sorry. Go ahead.
Your Honor, what we have is two motions to quash. They were filed about a week apart. The first motion was necessitated by our receiving word that third-party recipients of subpoenas directed to Wells Fargo and the Hayes County DA's office had told us that these subpoenas had been issued and served upon them. We were never provided with notice of the issuance of those subpoenas, and therefore we filed our motion on the grounds that the subpoenas violated Rule of Civil Procedure 191.5 and 205.2. So in that motion, we requested not only an order quashing those subpoenas, but also an order compelling defendant to produce all issued subpoenas to us and to the court. The second motion was necessitated by Mr. Henley's office issuing 9 more subpoenas to Wells Fargo after the filing of our initial motion to quash. Again, he failed to comply with TRCP 2052 by not giving 10 days notice of the subpoenas prior to issuing them. Now, I can see, because I've done it before, possibly inadvertently forgetting the requirement the first time, but these were issued a day or two after our filing of initial motion to quash, pointing out that fact. So in that motion, we did request fees for having to file it. And the responses to the motions are similar. With regard to the first motion, the response is that these are trial subpoenas. And that's interesting because the letters received from Wells Fargo, which are attached to our first motion as exhibits, say that the subpoenas require the production of records by May 27th. The trial date was never May 27th, and the letters from Wells say nothing about an appearance requirement. I haven't seen the subpoenas, so I can't tell you what's in them, but that doesn't sound like a trial subpoena to me. Defendant filed the response to the second motion this Wednesday. And again, the argument is that these are trial subpoenas. If you look at those subpoenas, which are attached, they provide the following. They're expressly 4 documents. That's in the title. They require compliance not on the trial date of July 27th, but on any date certain, but within 24 days. I can only assume a time frame other than 30 days was chosen to be able to argue that these were not discovery subpoenas, but trial subpoenas. But of course, there was no trial date 24 days after their issuance. They were also accompanied by business records affidavits. If defendant wants documents authenticated as business records, the way to do that, of course, is a deposition on written questions. But then again, I guess that would constitute an admission that the subpoenas were discovery products that they had to provide us notice of under the rules. Now, I'm sure Your Honor can see around that repeated end run, see these subpoenas for what they are, ones that require adherence to the rules of civil procedure, and grant our motions to quash.
Several things, Judge. Number one, the absolutely were trial subpoenas, but the fact is when you contact a bank like Wells Fargo, they're always going to insist, like, look, you're going to do it this way. We're not going to produce anything for you. And to obviate the need for driving a custodian of record down to the courthouse or providing a flash drive, we amended the subpoena request to comply with Wells Fargo's own parameters concerning 24 days. All of this, of course, would be unnecessary if Mr. Vassar had produced the bank records as we requested months ago, because Ms. Watson herself is a shareholder of Angel Sword Corporation. He sent me a curt letter rejecting any such request, that they would refuse to comply with that information. And as a result, Ms. Watson has been unable to discover the very components of her cases associated with her defenses or her own affirmative claims. Again, none of this was intended to circumvent their rights to notice of any kind. And if we're going to have to send out depositions on written questions, we will. But again, the whole purpose was with the anticipated need of having these documents produced and ready and for presentation at the trial, because I was actually surprised a little bit a couple of months ago when Your Honor said, well, let's just go ahead and set it for trial, and which was good news at the time. But it was like, okay, you better get the ball rolling here. So I don't see a basis for fees in the least for that. There was no malice or attempt to circumvent the rules.
So do you agree that you need to kind of redo these subpoenas then?
Yeah, well, yes, absolutely. And if they want notice of anything, I don't care about that. What we want is the documents, and what we would like, for the sake of clarity and ease of presentation of evidence. I mean, what we would prefer, of course, is if they would produce it all and we could probably stipulate to its admission. This frankly is probably a big collateral fight over nothing. But that is the kind
Mr. Vassar, have you produced the documents?
I thought we had, but obviously if we haven't, the remedy is a motion to compel. And I never even saw a letter. The letter he's talking about was a letter that says, hey, I'm a shareholder. You owe me books and records. That's the fight that you're about to hear about. If they've been requested in discovery, A, I think they've been produced. B, if they haven't, the remedy is a motion to compel.
All right, this is what I'm going to do. I'm going to go ahead and obviously grant the motion to quash, order you to reissue these subpoenas in the correct format. I'm not going to grant fees. Mr. Vassar, if you could go ahead and get me an order on this. Unfortunately, I need to take this is taking a little longer than I expected. So I'm going to have to take about a 15-minute break. We're going to reconvene. Let's see, what time is it? It's 11:18, correct, Texas time?
That's correct.
Yes.
All right, so let's reconvene at 11:30. I'm going to turn this Zoom off, and we'll be back on the Zoom at 11:30. So if you guys could go ahead and sign back onto the Zoom at 11:30.
All right. Thank you, Your Honor.
Thank you, Judge.